YouTube, it's Tone back with another one for you. This one here is a continuation of the Claim Your Credits PDF that we've been working on. That apparently took me 3 months to fucking get done, right? But this is the third video in this particular series that's gonna wrap this PDF up, and then next I'll be working on the private U.S. Treasury contract, UCC contract trust book that I'm going to be creating. It's going to have bond templates in it and all of that stuff to show you how to actually fund your actual account with the U.S. Treasury and things like that in order to use to be able to discharge debt and things like that. and and it'll have like an actual private trust document in there as well. It's similar to this, but it's a little bit different. Uh, so yeah. So whoever grabs that book will notice the difference, and you'll know what it is. But there is a big difference, and then one of them obviously is the bond funding the actual trust and the creation of your own private accounts and things like that. But to wrap this up here, I think we finished on Article 3, so we're gonna go to Article 4 right now, and we'll start there. So Article 4, Dispositive provisions. Whereas dispositive refers to something that settles a conflict or resolves a situation once and for all, the settlor grantor may freely act under all or any of the powers by this agreement given to him or her in all matters concerning the trust, after forming their judgment based upon all the circumstances of any particular situation according to love, truth, peace, freedom, and justice, and to determine the best course to pursue in the interest of the trust and the beneficiaries without the necessity of obtaining the consent or permission of any interested person or the consent or approval of any court. The managing director shall have the power to determine the allocation of receipts between corpus and income. The trust will have two beneficiaries for the life of the trust, and that those beneficiaries will be the same as the settlor and grantor. So you can change that number, obviously, if your beneficiaries are going to be different and stuff like that. The beneficiary page is at the bottom of this here. But you can change that at any point if you have a falling out or if one dies or something like that. You can always change that. But according to this particular document here, it's going to have two beneficiaries, and we'll go over that down at the bottom. So Article 5, Trustee Administrative Powers, Duties, and Responsibilities. Whereas settlor grantor grants the trustee power to assume the roles and title of board of trustees, secured party trustee, executive, director, or the administrator for the trust, and can and shall be carried out in accordance with trust agreement. The trustee shall be responsible for delegation of authority and for execution of the daily business of the trust, to include the right to execute and deliver all instruments or writings which it may deem advisable to carry out any of the foregoing powers on behalf of the beneficiaries. Only if the settlor grantor is incapacitated, incarcerated, or in any capacity that prevents settlor grantors from directing, handling said trust in accordance with to this trust indenture during the lifetime, and unless until both become incapacitated, the primary trustee of this revocable living trust shall be Jane Doe of Flower County, California. And in the event that the primary trustee passes away or becomes incapacitated, then the successor trustee shall be the surviving spouse or surviving oldest born, fostered, adopted child by body, common law, or other means, will serve as the acting trustee of this living trust. Trustee has all of the authority provided by the California State Republic, USA Non-Domestic Trust Code, with all rights retained therein. The trustee as a board shall hold all properties and assets of the trust in allodium, in fee simple, or in the highest form of absolute title, free title ownership available in joint tenancy with the trust. Such properties and assets shall not be owned by the trustee in their own private character and capacity, but by them in the trust name as fiduciaries for the benefit of the trust and the capital unit holders. Trustee B. Trustee executive Trustee and all successor trustees of this trust shall maintain an independent trustee status at all times. The trustee shall be subject to the standards recognized in law regarding the performance of the duties on behalf of the trust as provided by the common law for fiduciaries. And so fiduciaries are going to have obligations as well, right? And so that's what a lot of our the public officials actually are. They're actually trustees, and us being the beneficiaries, they're essentially the fiduciaries of the public trust, and they administer our estates because obviously nobody knows what the fuck is really going on in this fucking world. I mean, I would say country, but it's the fucking world, right? Nobody knows what the fuck's going on. These people do. So they're in a position right now where they are the trustees of the public trust. Not all of them are grimy, but a lot of them are, and they find ways to fucking suck the life out of these trusts, and that's what they're doing essentially. You know what I mean? Like, this is what's going on. So when you start to learn the structure of how these trust contracts operate, and you start to understand what the duties and obligations of the fiduciaries are, it makes it real clear to see what it is that's actually going on and what the fuck is supposed to be happening and what is not happening. You know what I mean? So there is rules and there is duties and there is obligations associated with what a trustee or a fiduciary is supposed to do in certain given situations according to law. You know what I mean? It isn't just up in the air freestyle. There is laws behind all of this, right? So B here says that the trustee shall be subject to the standards recognized in law regarding the performance of the duties, and duties is the big word, on behalf of the trust as provided by the common law for fiduciaries. No trustee, successor, or trustee or agent shall be liable for any acts or any omissions of any or prior trustees or agents. No successor trustee shall be personally liable for any act of the omission of any act required of him or her or his or her predecessor. With the approval of the board, and so that basically is limiting liability right there. So with the approval of the board, a successor trustee may accept the accounts rendered and the property and assets received as a full and complete discharge to the predecessor trustee without incurring any liability for doing so. To compromise, settle, arbitrate, or defend any claim or demand in favor of or against the trust in the favor of the beneficiary. So these are some of the things or obligations afforded to the fiduciary, and then some of the benefits being limited liability and things like that. So, and that's kind of just part of accepting the job, which is what that would be if you were going to be the fiduciary or trustee or whatever. And that's what it is. So, like, at the end of the day, that's what we are all doing as well. Because, anytime that we go to settle any of these matters that we're dealing with in any of these court situations and, traffic tickets, indictments, criminal charges, and things like that, essentially what we're doing is administering a trust or a estate on behalf of the entity being referenced, which is the estate, which is a lifeless, a fictional entity, a lifeless entity. It doesn't in and of itself have the ability or capacity to execute any of these actions. So us as the you know trustee, authorized representative, or whatever capacity that you want to go to settle the matter in, it obviously couldn't be in the capacity of the actual estate because nobody could actually be that. But that is in fact what is being referenced anytime that you're dealing with any of these public officials. That is what's being referenced. It's just made to look like your name, so a lot of people get it mixed up and think that they are the actual state ID, or that they are the actual certificate of live birth, or that they are the actual social security card and shit like that. But that is not you. Obviously, because if you can hold it in your fucking hand, it isn't you. How the hell could it be? Right? Come on. Use your head. So here we have to incur and pay the ordinary and necessary expenses of administration, including, but not by way of limitation, reasonable attorney fees, administration fees, notary fees, and the like. To initiate or defend at the expense of the offender any litigation for compensatory or punitive damages on behalf of the beneficiary. This agreement or any property of the trust estate to act through an agent or attorney in fact And that's what you would be, right? You would be either an agent or attorney. In fact, whenever you would be, making contact with any of these public officials as well, keep that in mind. You know what I mean? Because you don't want to approach them from the standpoint of the actual defendant or of or of any of these names that they want to place on the estate, which is basically commercial terms for commercial code violations, which are going to put you right in line to have to pay a penalty fee or something like that. But that particular entity, be it your all capital letter name, estate, could never make contact with these people, so you would have to do it from the standpoint of a attorney in fact or authorized representative or something along those lines. Trustee even, there's a few different hats that you could wear in order to settle and close, any of those particular matters there. So so you can act through an agent or attorney in fact by and under power of attorney. And that's another thing too, right? So you get your power of attorney and stuff like that too, duly executed by the settlor of the trustee in carrying out any of the authorized powers and duties. To appoint his/her successor trustee if either of the named trustees shall die, resign, become other named trustees, may, but shall not be required to appoint a successor. The appointment of a successor shall be made by duly acknowledged instrument delivered to the primary beneficiary and to the person, if any, then acting as the trustee. Trust specifically provides that a beneficiary and to the person, if any, then acting as trustee. Trust specifically provides that a trustee can delegate his powers through a limited term power of attorney to waive the payment of any compensation for the services, to interpret or construe the intent and direction of this trust indenture, to amend this indenture in accordance with the explicit instructions from settlor grantor. So Article 6, trustee indemnity and hold harmless. So settlor grantor instructs that the trust shall, without benefit of discussion and without division, does hereby expressly agree, covenant, and undertake the indemnification of, and does hold harmless the trustees from against but not limited to any and all claims or legal actions, orders, warrants, judgments, demands, liabilities, losses, depositions, summons, lawsuits, costs, fines, liens, levies, penalties, damages, interest, and expenses whatsoever, both absolute and contingent, as are due or may hereafter arise, to include such claims like that may hereafter arise with regard to any and all collateral of the trust, including but not limited to trust property listed in Schedule A for collateral, applicable by separate document presented herewith. The named trustee shall not be required to give any bond or other security. The trustee shall not be liable for any mistake of error or judgment in the administration of the trust, except for willful misconduct, so long as they continue to exercise their duties and powers in a capacity primarily in the interest of the beneficiary. Only if the settlor grantor is incapacitated, incarcerated, or in any capacity that prevents the settlor from handling said trust in accordance to this trust indenture, the trustee will not be liable to this revocable living trust, settlor grantor, or to the beneficiaries for any action or failure to act resulting in loss, harm to this revocable living trust. The settlor grantor or to the beneficiaries, except in the case of gross negligence, willful misconduct, or reckless indifference to the purpose of the trust or the interests of the beneficiaries. A trustee will only be responsible for his or her own acts, and no trustee will be liable for any act or actions occurring in this period before or after the tenor that trustee. Any outstanding liabilities of a dead, resigning, or removed trustee that are not discharged or affected by the trustee's death, resignation, or removal. Basically saying that if at any point, any of these trustees chose to take the trustee position, that they would not be held liable for the actions or actions that were not taken from anyone that came before them or after them. So, Article 7, revocability. This trust shall be revocable. However, the settlor expressly does not waive any rights, powers, privileges, whether alone or in conjunction with others, and regardless of when or from what source she may have acquired such rights or powers to alter, amend, invoke, ratify this trust, or any of the terms of this agreement in whole or in part at any time settlers deem fit at any time during the lifetime of the settler and while the settler grantor is not incapacitated, settler may subject to the other provisions of this section, revoke this revocable living trust in its entirety on delivery to the acting trustee of a written instrument signed by the settler grantor. In the event of such revocation, the remaining property will revert to the settler grantor after all debts and expenses attributable to the revocable living trust have been paid. This revocable living trust may not be revoked after death of the settler grantor. So basically, it's saying that if at any point you want to fire one of these people, right, and keep in mind that that's how this whole government system works too, all right? So when you understand that these public servants, these public officials are actually working for you on behalf of the estates of the American people, and then also to top it off, since we went into bankruptcy and the rescission of the gold clause, HJR 192, June 5th, 1933, rescission of the gold clause when we went off the gold standard and started using fiat currency. That was the initiation of the quantum financial system that is currently still being used. Like, if you wonder why these people can pull fucking money out of their assholes, it's because they're pulling it out of the quantum field. All right. It is a quantum financial system. It already exists. So all that bullshit about Nasara Jasara and all that fuckery was just to get people to look away from the fact that we're already operating in that system, and the way that the debt could and should and is still settled to this day, because I still do it, is by endorsing the payment coupons, which are the remittance slash payment coupons that get sent to you in the mail, which is your checks. That's your dividend cut from the performance bond. That is the application that you fill out to contract with any of these light companies, gas companies, hospitals, any of these places that are sending you bills. When you sign up and fill out an application with them, that actual application is not asking them for something. The application is you applying your credit and agreeing for them to be able to draw from your estate enough credit to operate their business. And so they do that in the form of turning your application into a marketable security that gets sold in the secondary markets as a performance bond. And so when that gets sold off in the secondary markets, the money that's made from that is what is the bill that they send you every month, which is a bill just like a $1 bill you have in your pocket. You know that's money. A $5 bill in your pocket, you know that's money. So when they send you a bill in the mail, you need to know that that's money too. Okay, so that's your money. So, and the point I was trying to make is that when, just like you can revoke your application with any of these companies, like company, gas company, you can turn your service off whenever. You can fire them whenever you want. Essentially, is that like that's what you'd be doing. You can do that to any of these public officials just the same. You have no obligation to entertain them if what they're doing is not in your benefit, because that is what their fucking job is. And not only can you fire them by just telling them that they're fired and you refuse to contract with them, you can go ahead and pull their bond and make sure that everybody in that building gets fucking fired too. You know what I mean? So it really comes down to how stupid that they want to be, really. So because you don't got to take it that far, because everybody's not bad in the system in general, but you do have a few bad abusive actors and shit like that do need to be dealt with from time to time, and there's different ways to deal with people like that. But anyway, because you know how in the Wizard of Oz, right, uh when they finally made it down to the wizard and they found out who the fuck that dude was, it was just some little old simple harmless fucking asshole behind the curtain screaming through a fucking microphone to sound like a monster. But you see how your mind can take and your imagination can take you down just a crazy path, and you just think that some things, everything is not what it seems. You know what I mean? And it's not, and it's really not as bad as you think. But if somebody can get in your mind, then then they can get you to do whatever they want without even having to pull a gun on you. So that's the latest war that we're in right now. Now we have psychological warfare going on, where these people are not running up on us with guns. We got chemical warfare, then we got psychological warfare. So that's what we got going on right now. So Article 8. This trust has been executed and delivered within the California State Republic, USA, non-domestic, and shall be construed and administered according to the laws of the Declaration of Independence, 1776, the Articles of Confederation, 1777, the Constitution for the United States of America, and the Bill of Rights, 1791, and over 225 years of American case law, common law, both prior to and after the undeclared federal corporate United States government bankruptcies of 1930 to 1938. And that goes into what we were just talking about with the 1933 rescinding the gold clause and all of that. That's when we went into the quantum financial system. And international law and treaties, the trust is vested in the principles of love, truth, peace, freedom, and justice, and is consummated upon common law. The situs and thereby the controlling interpretational laws under which the trust shall be construed may be changed to any other state or nation and shall be deemed prudent, wise, necessary, and appropriate by the seller. And that's what I was telling you too, up at the top. So like you can pick um the constitution from any state. You can pick any of your favorite principles. If it's some shit in the Bible, some verses that you like that could play into a person's character and the things that they do. You can use any of those things, and these are just basically laws that you're agreeing to be bound by, and the rules and stipulation upon which your trust duties and fiduciary obligations are to be executed. And it'll all be according to the rules and laws that you set in this particular contract, because laws are made by contracts. Because nobody has enough power to sit here and tell anybody what the fuck to do in this world at all. So, the way even that the Constitution is written is that, the people are governed by the consent, or the government is allowed to operate by the consent of the governed, meaning that if the people do not want to be governed by them, then they don't fucking have to. It's really that simple. But it isn't just a matter of you telling them that you don't want to be governed and then go start doing stupid ass bullshit. That is executed by your behavior, right? So, if you're interfering with somebody else's, health, or bringing physical harm to people, or interfering with somebody else's rights, then you're putting yourself in a position in a position where you do need to be governed from the outside in. And that's when there's these people obligations for the safety of everybody else to go ahead and step in. That is when they do have the right to cross the line with you. But other than that, you can tell them that, just to fuck off, and you wish not to deal with them at all, because you don't have to contract with anybody that you don't want to, right? Because we're operating under a maritime contract law system. So, and in any contract, even if you did by accident somehow agree to be bound by these fucking people, and they start doing some fuck shit to you, and you're like, yeah, I don't want to fucking deal with none of you people anymore on none of this bullshit. I didn't know what I was getting myself into. You have a right at any point to go ahead and rescind any contracts with your public servants if what they're doing does not seem to you to be in your benefit. Even though, mind you, a lot of the things that we do go through are for our benefit, even though we might feel like they're not. You know what I mean? Because there's lessons to be taken from everything. So take the lesson, not the loss. All right. So Article 9, other provisions, comments, remarks, additions, beneficiaries. Upon the death of the settlor grantor, the following individual will comprise the beneficiaries of this living trust. And then we get into it here. So the residuary beneficiary, all offspring, heirs, assigns created through the body, fostered and adopted by common law or other means of and by Jane Doe. B. Any heir or issue of those beneficiaries the same as though the body fostered and or adopted by common law or other means that is entitled to a benefit under this revocable living trust in the place of any deceased beneficiary. Amendment during grantor's lifetime. At any time during the lifetime of the settlor, and while the settlor is not incapacitated, the settlor may subject to the other provisions of this section, alter or amend this revocable living trust on delivery to the acting trustee of a written instrument signed by the settlor. Amendments may include, but are not limited to, the following: the settlor grantor may change the number and identity of the settlor grantor, the trustees, the successor trustees, or the beneficiaries. The settlor grantor may add or withdraw property from the revocable living trust. This revocable living trust may not be amended after the death of the settlor grantor. Distributions during the lifetime of the grantor. During the lifetime of the settlor, and while the settlor is not incapacitated, the acting trustee will distribute as much of the principal of the revocable living trust to the settlor as the settlor grantor may request. While the settlor is incapacitated and no longer able to continue to manage their own affairs, then the acting trustee may withhold or make payments out of the resources of this revocable living trust of any amount that the acting trustee in their sole judgment deem appropriate for the maintenance, comfort, and welfare of the settlor grantor. So they're basically saying here that, if you're on like your deathbed or you're fucking in a coma or some shit like that, that the trustee will have the right at that point to go ahead and operate the trust the way that they see fit in order to help you maintain whatever things it is that you need and things like that. So, distribution upon death of the grantor. Upon the death of the settlor grantor and after resolving all applicable legal debts and obligations of the settlor grantor, the acting trustee will expeditiously act to distribute the remaining property as directed in this section. After resolving all applicable legal debts and obligations of the settlor grantor, the acting trustee will distribute the remaining property in this revocable living trust in equal shares, individually the share and collectively the shares, to the following beneficiaries. A. All offspring created through the body, fostered and or adopted of and by common law or other means of Jane Doe. Where a beneficiary is under the age of 18 years old at the time of the final distribution, and that beneficiary is not an adult dependent beneficiary, the acting trustee will then act as trustee by holding that share for the beneficiary under the same terms and conditions as outlined in this revocable living trust, and will keep that share invested, pay the income or capital or as much of either or both as then acting trustee in their sole discretion consider advisable for the maintenance, education, advancement, or benefit of that beneficiary until that beneficiary reaches the age of 18, whereupon then the acting trustee will pay or transfer the rest and any residue of that share of all of it to the beneficiary. Where a beneficiary is an adult dependent beneficiary at the time of the final distribution, the acting trustee may, at their sole discretion, A, continue to act as trustee by holding the share of any adult dependent beneficiary subject to the same terms and conditions contained in this revocable living trust, and to keep that share invested and pay the income or capital or as much of either or both to then acting trustee uh, consider advisable for the maintenance, education, advancement, or benefit of that adult dependent beneficiary, or pay or transfer all the capital assets and property of that share to the amount remaining of that share to that adult beneficiary, subject to the same terms and conditions contained in this revocable living trust. If any of the named beneficiaries do not survive the settlor grantor by at least 30 days, but do have their heir assigned or issue who survives by at least 30 days, then the specific gift of the share designated for that beneficiary of whatever kind of character and wherever located will be distributed to those surviving heirs assigned or issue where those surviving heirs assigns or issues are not of the age of 18. The acting trustee will hold their share subject to the same terms and conditions contained in this revocable living trust. If any of the residual beneficiaries do not survive by 30 days, do not leave an heir, then that share designated for the beneficiary will revert to the residue of this revocable living trust. If all of the successor beneficiaries do not survive by at least 30 days, do not leave. Where is it? If any of the personal property to be distributed in this revocable living trust is subject to any encumbrances or liens, the final distribution, the beneficiary taking that property will take that property subject. Encumbrances or liens to the beneficiary may not be entitled to have any encumbrance or lien paid out or resolved by the remaining assets of the revocable living trust. All right, so subject to the laws of the universe and any and all applicable common law, no bond or security of any kind will be required of any trustee appointed to this revocable living trust agreement. A trustee may resign at any time for any reason. Hang on, let me write down this fucking time I got right here. All right, so uh, a trustee may resign at any time for any reason upon at least 30 days' notice to the settlor grantor if the settlor grantor is still alive, to any remaining trustee if there are any to the qualified beneficiaries, or the trustee dies, that trustee will cease to be a trustee as the date of their death. During the lifetime of the settlor grantor, and until the settlor becomes incapacitated, the settlor may remove a trustee for any reason or for no reason at the sole discretion of the settlor. After the death of the settlor, the qualified beneficiaries may, by unanimous vote of all qualified beneficiaries, remove a trustee for any reason or for no reason at the sole discretion of the qualified beneficiaries. At any time after the death of the settlor, a trustee by beneficiary vote may remove a trustee, and the trustee shall be the and the trustee shall be the oldest living heir assigned or issued by bond, fostered, adopted common law, or other means. Trustee replacement. At any time where the settlor is alive and not incapacitated, and where a trustee has been removed, died, resigned, or is no longer able to act as trustee for any reason, a replacement trustee may be appointed by the settlor. Where the settlor is dead or incapacitated, and where a trustee has been removed, died, resigned, or is no longer able to act as trustee for any reason, and where a replacement trustee is deemed necessary for the remaining acting trustee, a replacement trustee may be appointed by a majority vote of all acting trustees still able and authorized to act. Where the settlor grantor is dead or incapacitated, and where the revocable living trust is left with no trustee, a replacement trustee may be appointed by a unanimous vote of the qualified beneficiaries. Uh, Trustee powers. So, powers granted to an acting trustee of this revocable living trust include, but are not limited to, the following. The trustee will have the same rights and obligations to manage the property as if the trustee were the owner of the property. After the death of the settlor, the trustee will have the power to appoint one more individual or institutions to act as co-trustee where it is deemed reasonable and in the overall interest of this revocable living trust. Uh, C. The trustee may employ and rely on the advice of experts, including but not limited to legal counsel, accountants, and investment advisors to help in the management of the property where that hiring is deemed reasonable and in the best overall interests of this revocable living trust. The trustee may retain, exchange, insure, repair, improve, sell, or dispose of any and all personal property belongings to this revocable living trust as the trustee deems reasonable and in the best overall interest of this revocable trust without liability for loss or depreciation. The trustee may invest, manage, lease, rent, exchange, mortgage, sell, dispose of, or give options without being limited as to term, and to ensure, repair, improve, or add, or otherwise deal with any and all real property belonging to this revocable living trust as the trustee deems reasonable and in the best overall interest of this revocable living trust without liability for loss or depreciation. The trustee may maintain, continue, dissolve, change, or sell any business which is part of this revocable living trust, or purchase any business on behalf of this revocable living trust as the trustee deems reasonable and in the best interest of this revocable living trust. So, and I mean, that's really what you want to do. So, when you have these trusts set up, you got to understand that these are going to be running just like a business. You know what I mean? So, you don't just want to be blowing money. You want to make investments and be able to get your money back. Even though even just regular purchases really can be essentially looked at like a investment, because when you get your receipts back, you can always multiply your little receipts too, because keep in mind that we're dealing with fiat currency. So when we're dealing with fiat currency and securities and debt, debt-based money, we're dealing with debt notes, with circulating bills of exchange. When you get your receipts, those are evidence of debt. So any of these evidences of debt are actually money and can be monetized. So what I was trying to get at was that it can be looked at like an investment just to make a purchase somewhere where a transaction took place using debt notes, and really nothing really got transferred because we're dealing with debt. So at any of these points, people on both sides of that transaction can go ahead and 10x that transaction by just using the receipts and the account account printouts, right? So for any one tangible piece of physical property, which is what the receipt would be, which is what bonds are, these are all assets. So for any one piece of physical tangible assets, which are these securities, which is your receipts and stuff, you can 10x those, right? So could, because we're dealing with fractal reserve banking. So fractal reserve banking implies that you can go ahead and barter up to 10x the amount of any one piece of tangible property or any one tangible asset, which would be the actual security, be it your receipt, bond, and things of that nature. So that's kind of the cool part of dealing with, fiat currency. It's kind of like limitless money. So, but the point I'm trying to make is that when you get these trusts set up, you want to operate them just like a business. All right. So, like, that's the point. So, the trustee may purchase, maintain, convert, and liquidate investments or securities at reasonable risk and for the purpose of generating wealth and growth, and vote stock in person or by proxy, or exercise any option concerning any investment or securities as the trustee deems reasonable and in the best overall interest of this revocable living trust without liability for loss or depreciation. The trustee may open or close bank accounts wherever reasonable and in the best interest of this revocable living trust. The trustee may invest and reinvest the assets of this revocable living trust at reasonable risk for the purpose of generating wealth growth as the trustee deems reasonable and in the best overall interest of this revocable living trust without liability for loss. The trust may hold uninvested cash and unproductive property where it is reasonable and in the best interest of this revocable living trust to do so, including but not limited to for the purpose of protecting the capital and principal of this revocable living trust. The trustee may lend funds to any borrower where the loan is adequately secured by sufficient collateral and where the loan is reasonable and in the best overall interest of this revocable living trust. The trust may borrow funds from any lender and mortgage or otherwise encumber any assets belonging to this revocable living trust where the loan is reasonable and in the best interest. The trustee may maintain, settle, abandon, sue, or defend or otherwise deal with any claim where it is reasonable and in the best interest of this trust. Uh, where there are no other resources available and where the trustee is compelled to do so, the trustee may resolve any legally enforceable debts. Uh, debts, taxes, reasonable funeral expenses, burial expenses, and any expenses related to the final illness of the settlor, grantor, out of the resources of this revocable living trust. The trust may make the final distribution in any combination of cash and property. Property selection and valuation in the course of the final distribution will be made in good faith discretion of the trustee and will be binding on all beneficiaries. It is incumbent on the trustee to act as fiduciaries in good faith and in the best interest of this revocable living trust. All decisions of the acting trustee made in good faith regarding the management of this revocable living trust will be final and binding on all parties. The above authority and powers granted to the trustee are in addition to any powers and elective rights conferred by state or federal law or by other provisions of this revocable living trust and may be exercised as often as required and without application to or approval by any court. Any trustee who is not a beneficiary of this revocable trustee compensation. So any trustee who is not a beneficiary of this revocable living trust will receive reasonable compensation out of the resources of this revocable living trust for services rendered. A trustee who is also a beneficiary under this living trust will serve without compensation. Trustee expenses. A trustee is entitled to be reimbursed out of the wealth and property of this revocable living trust for any and all expenses, including interest where appropriate, where the expense is reasonably and properly incurred in the management of this revocable living trust. Spendthrift clause. No beneficiary of this living trust will have the power to transfer, sell, assign, or otherwise encumber any assets of the property held by this revocable living trust prior to final distribution by the acting trustee. Similarly, the rights of the distribution held by any beneficiary under this revocable living trust agreement will not be subject to judicial encumbrance prior to the final distribution by the acting trustee. Tax identification. So, keep in mind too that, before you even start doing these things, I mean, even though you can do it afterward, because you can always amend any of these forms, you want to go ahead and get your EIN. All right. So that's your employer identification number, and that'll be the numbers that you're going to use to bind with your social security number into this union that you're going to create this particular entity, which will act as a holding for all of the income that will be made between yourself, the real live living person, and the entity that you're creating by binding these two together. So when you do these things and you create these trusts, it gives you a level of protection and also limits your liability because it does a couple of things. So it protects you under the rules and stipulations associated with this particular contract, which kind of cuts off the government from being able to interfere with this particular contract because the government is not allowed to interfere with contracts, especially contracts in commerce and contracts in law. They have no authority to interfere with any of these contracts. So when you enter into a binding agreement where you're agreeing to only be subject by certain rules, stipulations, and things like that associated with this particular contract, the government is no longer able to enforce any of their codes and policies on you because you already have a legally binding contract with another entity and it's the one that you created. So that's how awesome it is to have your own little trust set up. But you want to get your EIN set up first, so that way you can go ahead and open up a bank account for this particular trust and things like that to be able to operate in the public. You know what I mean? Which is different from the trust that we set up with the treasury. But you can set up as many trusts as you want. I would recommend setting up one like this on the public side, and then getting my book that will be available in about a week or two, and you go ahead and get that. It'll show you how to set up your private trust with the U.S. Treasury, and that'll be bonded and funded on the private side. So you have public trust and you'll have your private trust that nobody will ever even know about besides you and the Treasury. So that's how that'll work. Which everybody should do at some point, because that is our fucking bank. If you were born here, then you can contract fucking directly with them. You don't got to deal with none of these banks like that. Tax identification purposes, for tax purposes, this revocable living trust will be identified by, and then your number here will be your EIN during the lifetime of the settler, along with your uh your social security number. So that'll identify the two entities that are being bound together in this particular contract. So homesteading tax exemption. If the principal residence of the settlor is held within the revocable living trust, the grantor maintains the right to possess and inhabit the residence without rent and free of charge for the duration of the maintenance, and the rights to possess and inhabit the residence without rent and lifetime. This is intended for the purpose of giving the settlor a beneficial interest and possessor rights in the residence, and to ensure that the settlor grantor does not lose any eligibility for a state homestead tax exemption, and that they would otherwise qualify for. All right, so vote of minor or adult dependent beneficiaries. So, vote of minor or adult dependent beneficiaries, where a beneficiary is a minor or adult dependent beneficiary and a vote, consent, or decision of the qualified beneficiary is required, then the parent, custodian, or guardian for that minor or adult dependent uh, beneficiary, acting in the best interest of that minor or adult dependent beneficiary, will be allowed to take the place of that minor or adult beneficiary for the purpose of that vote, consent, or decision when the parent, custodian, or guardian for that minor or adult dependent is of the body fostered, adopted by way of common law or other means. Termination of trust. This revocable living trust will terminate where the property of this revocable living trust is exhausted through distributions. In the event that the acting trustee concludes that the value of the property is insufficient to justify the cost of administration, and that the aggregate value of the property is less than the value of land resources, value, the acting trustee may terminate this revocable living trust after providing notice to the qualified beneficiaries. Where this revocable living trust is terminated under this section, the acting trustee will distribute the property in a manner consistent with and as described in the distribution sections of this revocable living trust. Basically saying that if the trust goes broke, that it's pointless to even have it in place. So you can't pay them. So they're not going to operate for free. So they'll just go ahead and shut it down. That's what makes it a revocable living trust. Abstract of trust. So the acting trustee may execute an abstract of this revocable living trust, the abstract of trust, and may present the abstract of trust to a financial institution as proof of the existence of the revocable living trust. The abstract of trust should not contain full details of the property holdings of the revocable living trust, nor should it name all of the beneficiaries of the living trust. Any person who is presented with an abstract of trust with regard to this revocable living trust will be held harmless for relying on the abstract of trust. So what they mean by that is that when you go to the bank with your EIN, what you would show them is the first page, basically showing the parties involved in the particular contract. You could show them the page with your EIN and your social together, and then you could show them like the notarized page. And so that would be enough, right? And you're gonna want to have page numbers on it so they'll see that there's what, fucking 20 pages, 15 pages in it. Okay. So they're gonna be like, all right, so they showed me the first and last page, but there's 20 in between that. So do the math. Obviously, there's something going on with this. So I would assume that there's an actual contract trust involved here, and not just bullshitting me, right? So that's how that'll work. So that's what the abstract of trust is. Governing law. This living trust will be governed in accordance with the laws of the universe as its highest and the common law of the State Republic of California, USA, non-domestic. And when they say USA, non-domestic, they use the three letters, one, two, three, for, and they use it on purpose. So because the US, United States, is different than the United States of America. Because if there was no difference, then they would be fucking spelled the same, but there's not. The United States, in and of itself, is a corporation set up in Washington, 10 square miles, where their authority lies therein, right? And they gain authority from outside of those 10 square miles by contract, right? So then when you start contracting with these particular agencies, essentially their authority and jurisdiction is going to flow out of that 10-mile square area to the particular buildings and agencies and agents that are contracting with them in the public. And that's why you may see them fucking riding down the street. You may see them inside of a fucking public building that they're renting and shit like that, and they'll call themselves, the FBI, they'll call themselves the CIA, they'll call themselves a bunch of different things. But essentially, what they are is just companies that contracted with Washington, D.C., 10 square miles out in Washington, fucking D.C. All right. And so that's the US. That's the United States. That's a company. That has the EIN. All right. They got a fucking employer identification number. So and the US, United States, sits on top of United States of America, which is the actual tangible landmass. All right. So that's why when you see USA here, that's what that's talking about, the landmass. So severability. If any provisions of this revocable living trust are deemed unenforceable, the remaining provisions will remain in full force and effect. Severability. Definitions. For the purpose of this revocable living trust, the following definitions will apply. Acting trustee means any trustee who is currently serving as a trustee of this revocable living trust. Adult dependent beneficiary means any adult beneficiary who is unable to manage their own financial affairs by reason of mental or other disability. Now, speaking about disabilities, like, a lot of us actually qualify to be disabled due to the fact that we are not competent to handle our own public affairs because they failed to teach us any of this shit in school. So, they only taught us how to operate in a fashion that fucking benefited everybody but us. So, technically, all of us can qualify as adult dependent beneficiaries whenever we're dealing with any of these fucking people at all. Because we don't know what the fuck they're even saying to us when we walk into these buildings and they're using legalese and we're speaking English, right? But they never tell you that there's a discrepancy in the languages either. They'll just go ahead and hand you a document and tell you to sign right here. It doesn't say what language that they're using in these documents. You just assume it's English, and they assume that you don't fucking know, and they kind of like it that way. And they kind of like it that way. So, that's just what it is. So technically, I think that all of us qualify as adult dependent beneficiaries due to reason of mental disability, uh, due to the fact of our ignorance and inability to manage our own financial affairs because we've never been taught finance. You know what I mean? So age of majority means the age of majority of the jurisdiction where a beneficiary ordinarily resides. Incapacity or incapacitated means when a person is unable to manage their own financial affairs by reason of mental or other disability. Minor beneficiary means a beneficiary who is under the legal age of majority. Trustee means any primary trustee or successor trustee, as well as any replacement or additional trustee appointed for this revocable living trust. Qualified beneficiary means any beneficiary that is entitled to a benefit under this revocable living trust. Definition of Board of Trustees. Uh, the people or entities who receive and hold a capital unit are under the beneficiaries of the trust. Receipt of a capital unit from this trust is evidence of entitlement to receive disbursements of income, properties, or assets from the trust upon distribution and upon the trust termination. Uh, Definition of protector. The person who acts in the best interest of the beneficiaries and ensures that the independent trustee of the Board of Trustees act in accordance with the trust contract and the intent of the creator. Definition of trustee. The people or persons that hold the properties and assets of the trust subject to the terms and conditions of the contract for the benefit of trust and the capital unit holders. Trustee refers to the single, multiple, and successor trustees who at any time may be appointed or elected or who act in a fiduciary capacity under the terms of the contract and the conditions. So, in witness thereof, the parties hereto have signed their names, and it has the name, date, and all that shit there. You can go ahead and edit all that up, right? Uh, and then you have your witness signature areas. So you got the three witnesses here, uh, and you can set those up however you want. You know what I mean? Usually want your three witnesses. the way that and so the private trust is, set up a little bit different. But here in the public unit, you're gonna want your three witnesses there. So acknowledgement and certification of the appointment of trustee. Know all men and women by these presents that I, settler grantee Jane Doe, deposes and says on this day and date the following trustees have been appointed for the JMD Revocable Living Trust in accordance with the terms and conditions of the trust contract as of the date of indicated below. The authority, duties, powers, and responsibilities of the trustee are detailed in the contract. Its attachments and its minutes must be referred to by the trustees as the authority for any acts performed by him or her in any said capacity. Anyone and all third parties can rely on this document to establish the authority and powers of name, and in so recognizing the authority and powers of the named trustee will be held harmless from any acts done, any acts purported to be done, or omissions made in the name of JMD, Revocable Living Trust, in his or her capacity as trustee. The creator of this trust, whose name under seal is subscribed to this document, has been by subscription acknowledged that he or she has appointed to the office of trustee and has explained the obligations and duties thereof and acknowledges as creator his intentions are to have Jane Doe serve as the trustee subject to the terms and conditions of this contract trust as put forth by the undersigned creator and thereby settles this contract with the trustee acceptance of $21 of gold and silver coin or money. All right, so you got the gold bond here set up for that. All right, so acceptance of $21 of gold or silver money on the Republic for the United States of America as good and valuable consideration, and the trustees thereby exchanges to the creator of or of one designated by him or her the name and seal of the person named as the creator of the revocable living trust. The acceptance and signing of this indenture by the trustees shall constitute the contract, and the signing and acknowledgement of appropriate trust minutes thereafter by the settlor's grantor shall constitute the acceptance of the trust indenture and the trust property in the same manner as the trustees without further act or conveyance. In witness thereof, have executed this agreement in and on the date set forth above. Perjury. So you're signing here under the penalty of perjury as well. All right. I affirm under the penalty of perjury under the laws of the United States of America that the foregoing is true and correct to the best of my belief and informed knowledge. And further, deponent sayeth not, I now affix my signature and official seal to all of these above affirmations with explicit reservation of all my unalienable rights without prejudice to any of those rights. Then you got your signatures down there. All right, so statement of witness. The foregoing certified declaration of revocable living trust indenture for Revocable Living Trust Organization named JMD Trust, consisting of 21 pages, including this page, was signed in our presence by Jane Doe. We, at the request and in presence of the settler grantor and in the presence of each other, have subscribed our names below as witnesses. We declare that we are of sound mind and in the proper age to witness as Revocable Living Trust that, to the best of our knowledge, the settler grantee is of the same age of majority or is otherwise legally competent to make a revocable living trust and appears of sound mind and under no undue influence or constraint within the domicile of the California State Republic, USA, non-domestic. Then you got your penalty of perjury here. You got your three more witnesses. All right, so we're getting down to the bottom of this shit here. So certification of notary public. So this is the notary's page. Using a notary on this document does not constitute any adhesion. And so the reason why for this statement here is because sometimes they like to try to include you in a commercial code or statute based on the fact that you use a public notary. So they may try to make this particular entity subject to some type of code or statute based on the fact that there was currency involved. Because to get something notarized, it usually costs money, unless you get it done at your bank or something like that for free. But essentially, the way that they could try and take a private contract like this and try to make it, in fact, subject to codes or statutes would be through a notary public, because that usually is what their purpose is to act as a conduit between the public and private. So like that's how you'd be able to have like a private document legal in the public, and you would use the notary public stamp as the conduit to be able to bring that document into their realm. So you could look at it in the sense that, like, if you brought one of these contracts to court and it wasn't notarized, a judge would look at it but technically couldn't see it because it doesn't exist in his realm because they operate in the public. You know what I mean? So that's kind of how that works. The way around that, if you have an issue even with this shit, is that you can notarize your own documents as well. Keep in mind, you can take the position of any government official if you ever feel like you need to in order to get something done. You know what I mean? So, a lot of these public officials only have the ability to be in the seats that they're in because they're doing jobs that we don't fucking want to do. And to be honest with you, I think a lot of them don't want to fucking do it either. And some of them are probably even there for the wrong fucking reasons. You know what I mean? I mean, a lot of them are just fucking actors that somebody put there because they needed somebody in that position to be able to do some other shit. So a lot of them are just fucking actors and working with like some whole other team and shit. You know what I mean? And don't even fucking want to be there. But just in general, a lot of them are taking those particular positions because that's shit that we don't want to fucking do. But we do have the right to take any of those positions if we ever need them to execute any of these actions. And I say that to say that you can notarize any of these fucking documents yourself if you want to by just putting your fingerprint on it, or you can put a $1 stamp down, go ahead and cancel the stamp, 45-degree angle, corner to corner, sign over that stamp, go ahead and put your fingerprint on it, and that's a notarized document right there. You know what I mean? So if there was an issue of you being worried about getting dragged into a adhesion contract by using, said public notary, there's ways around all that shit. There's ways around all that shit. So here we got schedule. All right, so we're almost done with this shit too. We probably got about like 10 more minutes maybe. So schedule A, trust property, entered into this state date on, whatever date, 2024, by and said between the settlers grantor hereto the trustees, sovereign state citizen. Just be careful with the names that you use on these things. I don't know if I agree with that shit. I would probably just put like a private, private citizen. You don't gotta fucking be throwing sovereign all up in shit all the time. You know what I mean? It's kind of dumb to be honest with you, but you can put private citizens fine. Within the domicile of California, USA, non-domestic for the scheduling of assets. Even though, mind you, we all are sovereign, and I mean the documents even say that the American people are a sovereign nation. So, for people to try to talk shit about you saying that, they're probably just fucking trolls. You know what I mean? To be honest with you, or somebody that has never read the Constitution. So, you could let them say whatever they want. Really, it really doesn't matter. So, Revocable Living Trust Organization, in harmony with the trust indenture and the trust organization bylaws, settlers grantors hereby conveys the following described property and is accepted by the trustee by and on behalf of the trust. The settler assigns, conveys, and delivers to this revocable living trust all of the rights, titles, and interests, tangible or intangible, to any and all properties, real or personal. This list of property is comprehensive, and I mean it is. It's super comprehensive. Just means that there's a lot of moving parts to it, and it goes into a lot of detail, and is written the description of those certain properties which are agreed upon and known to both settler, grantor, and trustee at the time of the execution of the trust indenture, and includes all property transferred and accepted to wit. One, all tangible and intangible assets, any and all intellectual property created in both the past, present, and future in the name of Jane Doe, any given variation of the name, along with JMD Revocable Living Trust, identified by name or number, social security number, right? And so when you bind both of these agencies together, um, be it your EIN, your social security number, and all of that shit, then you can use any of those numbers to identify yourself moving forward because they're pretty much one and the same anyway. Uh, and then you got your penalty of perjury here. That's called a jurat. Penalty of perjury signature is called a jurat signature, and that's where when you go to get it notarized, they're going to tell you to put your right hand up and swear under the penalty of perjury against your document, and that is called a jurat notary. Acknowledgement and acceptance by trustees. Uh, so the party trustee duly appointed by the settler grantor Jane Doe Revocable Living Trust Organization as first trustee herein accepts the duty as trustee. JMD Revocable Living Trust and herein declares that this trust is in full effect as the trustee by signing this acknowledgement and acceptance hereby acknowledges in good faith and in accordance with the terms of the trust on behalf of the beneficiaries, the trust organization bylaws, which will be the stipulations, and all the resolutions of the managing directors of this trust interpreting the same as recorded in the minutes or meetings from time to time, which shall serve as the governing instruments of the board. This trustee further agrees to manage, protect, and preserve the trust estate through the prudent exercise of powers and authorities provided within the trust indenture. Then you have your further perjury jurat notary here, right? So you're gonna just keep on signing under the penalty of perjury, which a lot of these people never even do when they send you all these offers and shit like that, and really make you feel like you have obligations to entertain them. None of them are sending you affidavits. None of them are sending you, obligations and fucking demands like under the penalty of perjury, swearing that they even have the power to do any of that shit, right? But because nobody questions them, they just fucking get away with it. Memorandum of Trust Declaration. Who's ever has ears, this is fucking strange, right? Whoever has ears, let them hear. Whoever has eyes, let them see. By these presents that I, Jane Doe, is a managing director, created a revocable living trust known as JMD Living Trust and JMD Holding Company. Trust is dated XYZ 2024. This memorandum of trust declaration is executed as evidence of the existence of the foregoing certified declaration of trust indenture. Any person may rely upon this memorandum and trust declaration as evidence of the existence and said declaration of trust and is relieved of any obligation to verify that any transaction entered into by a trustee thereunder is consistent with the terms and conditions of said declaration of trust. The trustee is a sovereign state citizen. Mind you, sovereign and citizen can never be in the same fuck. So just be careful with what you put together. You know what I mean? The declaration of trust and trust created thereunder may be referred to by the name JMD Holding Company or JMD Living Trust, Revocable Living Trust Organization. Then you got your perjury jurat signature again. That's a lot of notaries. Affidavit of identification, right? So here you go. You got your number, you got your EIN. So you're going to put your face right there, tie it right up into your EIN. Trustee does hereby affirms and establishes that below is the one true called Jane Doe settler grantors and duly appointed managing directors of this affidavit of trust identification shall be used as a form of identification. This affidavit of trust identification instrument is the copyrighted intellectual property of JMD Holding Company. Notice is hereby given that JMD Holding Company insures, indemnifies, and holds harmless one called Jane Doe, herein referred to as settler against any claims or changes on by public trustees or agents conducting business for a separate foreign trust while conducting official business in accordance with the trust. And this is a really big statement right here because this is what they do a lot of the times and people don't even realize it, right? So, when you're dealing with a lot of these agencies and government organizations, they are in fact operating under a foreign trust and trying to fund it with the taxpayers' money by finding ways to monetize everybody's fucking pain and shit like that. So, like all these criminal charges and things like that, these are all getting monetized behind the scenes. You know what I mean? These are all getting sold as bonds and shit like that too, and everybody fucking knows. They just don't talk about it because there really is a lot of money involved with it. But it's illegal. If you want to just call it what it is. But there's just so much money behind all that shit that, even just talking about it, you fuck around and get smoked off that shit. Like these people are assholes, bro. To be honest with you, straight up fucking assholes. So yeah, so I only stopped it just to say that. So notice is hereby given that JMD Holding insures, indemnifies, and holds harmless the one called Jane Doe hereinafter referred to as settler grantee against any claims or changes on by public trustees and or agents conducting business for a separate foreign trust while conducting official business in accordance with the trust. All right. Because that's what they're doing all the time. That you get harassed by all these people, they're operating for foreign trusts. More than likely, people that don't even live in this fucking country. And that's who they're working for. All right. So a lot of them are fucking compromised and taking over and shit like that. And I'm not saying that all the people who work there are bad, especially people from this country who are just looking for a job, who are mentally disabled because they fucked us over in the whole educational system. I'm not blaming any of those people, but there's people who know exactly what the fuck's going on, and I just happen to be one of them too. So settler grantee must not be delayed, arrested, impeded, or detained by any foreign officials, any interloping by any foreign powers into JMD Holding Company Trust Administration must be subject to JMD Living Trust fee schedule and claim for damages. And that's another big thing too, is that you always want to get your fee schedule included in there. So that way, when they violate any of your stipulations, you don't have to sue them anymore. You can go right to the Department of Risk Management or the Secretary of State where they have their bonds registered at, and you just list the violations. The violations won't be hard to fucking prove because it'll usually be in the form of a fucking ticket, a fucking indictment, a criminal charge. It'll be something along those lines where they handed you some shit with their company fucking letterhead on it, like the state of or uh whatever district court with their company letterhead on it with your fucking name on it trying to draw your private credit, and you already have all your fee schedules here. You don't have to prove that they fucking did it. They handed it right the fuck to you. So you just go ahead and put them on notice and send them the fucking bill. And then if they're either going to pay you in 30 days, if they don't, then you just go, pull it out of their bond and notify their fucking insurance company that they're fucking engaging in criminal activities and shit, and they'll probably just pull their coverage right there. Everybody will be fucking unemployed in fucking 30 days. Just like that. You don't gotta be anybody special. You don't gotta have no fucking none of that. That's how much power one person has. So if you wonder why there's things that they don't want you to know, like your rights and shit, that's one of the reasons. So herein enclosed is a captured likeness of the reflection of the one called Jane Doe, protector, and is authorized to present this affidavit for verification purposes. So again, then you have your perjury, jurat, notary going on right there again. Certification of trust. So secured party trustee confirms the following facts. The JMD Holding Company is currently in existence and was created on this day. The settler grantor of the trust are as follows. The currently acting trustee of the trust is Jane Doe, secured party trustee. The power of the trustees include but are not limited to A. The powers to convey and exchange. B. The powers to enter into and cancel contracts. 5. The trust is revocable. 6. The trust does not have multiple trustees. 7. The trust identification number is as follows. 8. Title to trust assets shall be taken by Jane Doe, trustee, acting as managing director for this trust after acknowledgement of the initial exchange. 9. The trust has two beneficiaries and is the same as the settler grantor. The undersigned trustee hereby declares that the trust has not been revoked, modified, or amended in any manner which would cause the representations contained herein to be incorrect. The certification is being signed by the currently acting trustee. So then again, you'll have your perjury, jurat notary again. So certified declaration of living trust, beneficiaries. I know all men and women by these presents that I, Jane Doe, being first duly sworn, deposes and says, unless otherwise stated, I have individual knowledge of the matters contained within the certificate. I am fully competent to testify with respect to these matters. The foregoing certified declaration of trust beneficiaries for Revocable Living Trust Organization JMD Trust being duly organized under the state republic laws of California, trust identification number must satisfy the following requirements. So the definition of beneficiaries, the people or entities who receive and hold a capital unit are the beneficiaries. Uh, Receipt of capital unit from the trust is evidence of entitlement to receive disbursements of income, properties, or assets from the trust upon distribution or the termination. Definition of protect is the person who acts in the best interest of the beneficiaries and ensures that independent trustees of the Board of Trustees act in accordance with the trust contract and the intent of the creator. The people or persons that hold property and assets of the trust subject to the terms and conditions of the contract for the benefit of trust and the capital unit holders. Trustee refers to the single, multiple, and successor trustee who at any time may be appointed or elected and who act in fiduciary capacity under the terms and conditions of the contract. Trust requirements. Pursuant to the common laws of the California State Republic, USA non-domestic, and shall be interpreted and construed under the Declaration of Independence, 1776, the Articles of Confederation, 1777, the Constitution for the United States of America, and the Bill of Rights, 1791, and over 225 years of American case law, common law, both prior to and after undeclared federal corporate United States government bankruptcies of 1930 to 1938, and international laws and treaties. And the reason why they bring that up is because we were using actual law prior to that. And then when we went into the fiat banking system, there was no longer laws. There was codes and statutes and violations, and that's when they created the fictional versions of us at that point in order to try to uh, have some type of hold over the people and shit. And I don't think at that time that it was a big deal because I think most people understood how uh to administer the fucking estate, but the knowledge has just been lost. And as time went, they go and do these resets, they fucking move people around and shit like that, shuffle shit up, burn down fucking libraries, fuck people up, throw people in jail. They cause a lot of fucking nonsense in order to hope that people forget what it is that they're supposed to do and shit. So at one point everybody knew how to do the shit that we talk about. So the trust is a valid trust under the state republic laws of California, or would be, but for the fact that there is no corpus. The trust is revocable or by its terms became revocable. The beneficiaries of the trust who are beneficiaries with respect to the trust interest, settlor, grantor, benefit are identifiable from the trust instrument. The people or entities who are the beneficiaries of this trust are entitled to receive disbursement of the income, property, or assets from the trust upon a distribution or upon the trust termination. So document requirements. And then on the last page, we got the list of beneficiaries here. So that's how that shit all goes right there, man. And if you want this free PDF, let me know. I'm gonna also create a editable version of this that's gonna be included with the private trust book that I'm gonna be creating for the U.S. Treasury UCC contract trust packet. And so I'm gonna have all the bonds in there, the bond templates, how to fill out your UCC filing, how to create your bond, how to create your bill of exchange, how to create your chargeback, how to how to create your power of attorney, and things like that will all be included in my book. And then I'm gonna also have this a editable version for free included with my book. But this PDF in and of itself, the way that it sits like right now, is already free. So you can just ask for this if you need it. It's called Claim Your Credits. Just send me an email and I'll go ahead and send it to you. So it is the game of chess. Stop playing checkers with these clowns. And that's what I got for you for now. Until we meet again.